During his term as president, Jacob Zuma had security upgrades done to his private homestead known as Nkandla. But these upgrades unlawfully included non-security features for which taxpayers footed a bill of roughly 250 million rand at the time. In her report entitled Secure in Comfort, the then public protector, Thuli Madonsela, concluded that the president was to pay, personally, a reasonable proportion of the cost of these non-security features. I'm Cecelia Cock and this is Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom. The case, Economic Freedom Fighters versus Speaker of the National Assembly and Others, or the Nkandla case, as it's known colloquially, deals with the Public Protector's report Secure in Comfort. Essentially, the case does two things. First, it clarifies the scope of the Public Protector's powers. Before the case, there was much debate as to the legal force of any remedial action the Public Protector might order. The court settles the question. Second, the court finds that the actions of two of the three branches of government, namely the executive, in the form of its head, the president, and Parliament, had acted unconstitutionally in light of the Public Protector's report on Nkandla. The judgment refers to the Public Protector as, and I quote, one of the true crusaders and champions of anti-corruption and clean governance. There were various parties to the case. For the purposes of this episode, the most important are the Economic Freedom Fighters and the Democratic Alliance. The Public Protector herself was admitted to the court proceedings as an amicus curiae, in other words, a friend of the court.
Public Protector, my client, was not going to settle for anything other than the actual implementation of the actual remedial action which she had imposed, and she was not prepared to allow for a tinkering with that remedial action.
I sat down with senior counsel Gilbert, who acted for Thuli Madonsela in the case.
I don't think it's unfair to say that she was the first effective public protector in the sense that she was perfectly willing to take on the most powerful in the country, including the president himself.
I also spoke to Professor Thuli Madonsela herself. Professor Thuli Madonsela, it is a great privilege to be sitting with you and to have the chance to discuss the famous Nkandla case, which called out the President as well as the National Assembly for acting unlawfully and unconstitutionally. And you were very much involved in the case, given that at the heart of it was your report, Secure in Comfort. Can you tell us a little bit about that report?
The report of the Public Protector, Secure in Comfort, was about over-expenditure on public resources at the private residence of the President. And all of this was done in the name of security. The instrument concerned allowed them to provide security, but it's the kind of security that is provided in people's homes. It might be an alarm system, a camera there, and probably some kind of fencing for the home. But in this particular case, they had strange things like a chicken coop that nobody had ever seen in this country because they'd borrowed it from England. They had extensive paving there. They had an amphitheater and a swimming pool that they insisted was a fire pool.
I sat down with senior counsel Wim Trengove too. Wim acted on behalf of the Economic Freedom Fighters, who were the main applicants in the case.
The report first went to Parliament, and instead of implementing the recommendation that Treasury and SAPS put a value on the improvements at Nkandla, which had no security underpinning, Parliament chose to mandate the Minister of Police to make that assessment. And the Minister of Police then came back with his farcical assessment and presented this case that there were actually no improvements at all, which did not have a security underpinning. And you remember the demonstration with the fire pool and so on, how absurd that was, and how the minister was seen in public to demean himself in service of his loyalty to the president.
At the end of the day, all of this was done at $250 million of public resources. If you thought that was unjust and unconscionable, there was an additional element in that literally the money was transferred from a fund that was for urban renewal in Durban, which was meant to end unemployment. And one of the staff members specifically warned them against that this money is earmarked to end poverty. It can't go to provide luxuries for anyone, even if it's the president. And all they did was just to remove that person sideways and continue with the process.
The case was launched by, not by me, but by my colleague Tembeka Nkandla, with the exuberance of youth. He launched this application on behalf of the EFF directly to the Constitutional Court, which was actually quite a long shot. The DA, being a bit more conservative, launched a similar application in the Cape High Court. But I was then asked to come in and assist on the EFF side. The story was long and colourful in coming. And that was, I think, what ultimately culminated in the realization by the political parties, first the EFF and then the DA, that the political process is not going to solve this problem, and that they should go to court. The difference then was that the EFF and Tembeka had the chutzpah to go straight to the Constitutional Court and pulled it off. There are very narrow grounds on which one is entitled to go directly to the Constitutional Court. One of those grounds is if the basis of the case is that the President or Parliament has acted in breach of their duties under the Constitution. But even that exception has been very narrowly interpreted by the courts to be confined to not just any constitutional breach, but a breach which is, quote, agent-specific. In other words, breach of a duty which is imposed on the President in particular, not merely duties which are imposed on the executive or on anybody else. So what you need to show is that the President was in breach of a constitutional duty which the Constitution imposes on him in particular, or on Parliament in particular. And it wasn't clear that we would succeed in persuading the Constitutional Court that this was such an occasion. The second leg was that there was a duty on Parliament in particular to hold the executive to account, which they didn't do in this case. So those two pegs gave us the license to have this case heard by the Constitutional Court. But I can tell you that when courts want to hear cases, they find it easier to find reasons to do so than when they don't. And I suspect that on this occasion, the Constitutional Court saw that it was important for them to hear the case rather than to duck it.
What was the legal context of the Nkandla case?
This issue about the status of the public protector's orders and whether they were binding or not was a hotly debated issue over a long period of time. There were some respectable lawyers who were of the view that her orders had no standing at all, no legal effect at all. A Cape Court had held that they had almost no standing, that that those subject to her orders could ignore them if it was rational to do so, which is a very low threshold. Shortly before the Concord hearing, the Supreme Court of Appeal for the first time held that her orders were binding. So there was a countervailing authority of some substance, but the issue was now up for debate in the Constitutional Court.
Gilbert came to be Thuli Madonsela's counsel because he had represented her in a previous case. The very Supreme Court of Appeal case Wim just mentioned, which held that the public protector's orders were binding.
I first was briefed by her not in the Nkandla matter, but in the SABC matter involving Hlaudi Motsoeneng, in respect of which she gave, funnily enough, a modest but obvious report.
Hlaudi Motsoeneng headed up South Africa's public broadcaster during some of the Zuma era. Motsoeneng's tenure was filled with scandals, and because of this, he was at the centre of much litigation. The case that Gilbert is describing actually brought an end to his career as the CEO of the broadcaster. In her report, Thuli Madonsela recommended that the broadcaster's board take corrective action against Motsoeneng, amongst other things, for lying about his qualifications. Her report was, however, simply ignored.
This was a man who had falsified his qualifications and was nevertheless appointed to the job. And she had, the extent of her remedial action, which is the term used in the Constitution, was to require that he be subjected to a disciplinary inquiry. Hardly a radical recommendation, particularly given the facts of the case. That case went all the way to the Supreme Court of Appeal, which was really the first occasion where we argued that her remedial powers were not simply recommendatory, that the term remedial action, which was the term used in the Constitution, meant that her determinations were enforceable unless and until they were judicially reviewed and set aside. So the judgment of the Supreme Court of Appeal, I think, laid the foundation for that.
The Nkandla case came before the court during the era of StateCapture. This was a time during which state institutions were being undermined to benefit the then President Zuma and his cronies. It was not a foregone conclusion that under the intense political stress there was, the courts would remain independent and defend the Constitution.
There were two, I think, competing social forces at play. The one was that it was certainly, the Public Protector's report was used as a stick by all the opposition parties with which to beat the president. But it also came at a time when there was increased and heightened tension between the judiciary and the executive. There had been a very high-level meeting about 6 or 7 months before the matter came to court between the heads of court and the president and the deputy president at the time, in order to deal with the judiciary's principal concern that there had been these very strident attacks on the judiciary for what was called judicial overreach, trespassing into the separation of powers, and the judiciary was equally concerned with the impact of attacks upon them as an institution emanating from the highest holders of political office. So it was a delicate time.
Me and the Chief Justice found ourselves in an atmosphere where society was watching.
Because the executive and legislative branches of government were compromised, was the judiciary called on to do more heavy lifting than it would ordinarily have to do in a functioning democracy?
I have no doubt that that is so. And I do think that the appropriate role of the courts depends to some extent on the environment and the circumstances. And where, in this case, both Parliament and the Executive were failing and betraying their duties under the Constitution, I think there was an enhanced duty on the courts to make a stand for the Constitution, and that's what happened.
The message that sends to the public is that we are a rule of law country. When judges make a final decision and say that nobody is above the law and everybody is accountable for their actions, public power must be exercised in accordance with the law and in the public interest, and it doesn't matter who would be exercising that power. That rebuilds trust among the ordinary people, that those they've entrusted with public power will be guarded to make sure that they use public power for the purpose it was given.
Did the political circumstances make it particularly difficult for the court to do what it ultimately did?
Of course, courts will tell you that they don't make a choice in either upholding the rule of law or not, and that they simply implement what the Constitution requires of them. But if the truth be known, the line is often a vague one and has to be drawn by courts, and they do sometimes tend to do so more aggressively than others. Bear in mind that in this case were two important features. The one is, as you mentioned, that it was a case against the President and Parliament, the very peak of executive and legislative power. But the competing participant before the court was the public protector, who at that time had huge public stature. So, and also a member of the executive branch in a broad sense. So it wasn't purely the people versus the president. It was a far more complex power relation before the court. And the fact that the public protector at that time was somebody who was so universally admired, I think helped a lot.
What about the potential for abuse of the powers of the public protector? In this regard, we need only think of Thuli Madonsela's successor, Busisiwe Mkhwebane. We'll discuss Mkhwebane later on in the episode.
We already have a very powerful executive and a very powerful parliament, and all other things being equal, it serves as a valuable check that we also have at least a third repository of real power, i.e. in the public protector. All power can be abused, but let's have our salvation lies in a distribution of powers in numerous places rather than to focus it all in Parliament and the executive.
I do think that the personality of Thuli Madonsela played a role. And I always say you must be careful for what you wish. It's all very well when you have a public protector of the caliber of Thuli Madonsela who brings a truly independent mind to bear and is not scared to take on the rich and the powerful. That's one thing, but you can have a small-minded or a petty, shall I say, public protector who ignores the high-profile and important cases and chooses rather to take on the lesser cases, and then one is saddled with the proposition that those decisions stand unless and until set aside by a court. And so all I can say is one hopes that the example set by Thuli Madonsela will be followed. That's all I can hope for.
It's the risk we take in all democratic institutions. I think choosing the right person with the right skills and the right experience positions that person to be able to do their job without fear or favor. And that includes being able to deal with powerful figures such as the president. It doesn't matter where the person came from, but I do want to say to you, it does matter though who appointed you. In my case, I was appointed by the president, but I wasn't nominated by him. If I had been nominated by the president nefariously, it would have impacted on my office. With the Chief Justice, it's an open arrangement. We all know that the President nominates, so it doesn't happen undercover. The Chief Justice is nominated by the President. The President is supposed to consult with constitutional parties and then, or with the leader of the opposition and then appoint. Of course, he might not really regard what the opposition has to say. But imagine if I had been secretly nominated by the President. And between me and him, we knew that the only reason I'm in office is him. My behavior would be different than, and I must admit that my candidacy was supported by the president beyond the administrative appointment, but he didn't nominate me. Going forward, I would prefer the American approach where the president nominates and there is a proper vetting process in Parliament, so that if there are any shenanigans that are going on in the background, those could possibly come to the fore, or if there's a particular group that has a vested interest in a person's candidacy, we could at least sense in the public that the support is coming from a particular corner.
Thuli Madonsela was succeeded by Busisiwe Mkhwebane. Mkhwebane's term has been fraught with controversy and much litigation. She's been found to have lied under oath and to have acted in bad faith by the Constitutional Court. The Apex Court even slammed Mkhwebane with a personal cost order. According to this court, such orders are only granted, and I quote, when public officials fall egregiously short of what is required by them. The Chief Justice, who penned the Nkandla judgment on behalf of a unanimous court, refers to the public protector as the embodiment of a biblical David fighting the most powerful and well-resourced Goliath, namely corrupt government officials.
It was a very potent judgment, and these days delivered on national TV, so its impact is immeasurably greater than it would have been in the old days. And you'll remember from that time, it had a spectacular impact, that judgment. And certainly one thing one could say of this Chief Justice is that he has shown some leadership. Our tradition has always been for Chief Justices to be soft-spoken and seldom heard, but he has adopted a very upfront style of leadership which served us well in hard times.
I was curious about the president's strategy in the Nkandla matter. Before the case, the National Assembly, without actually having the power to do so, absolved the president of liability. It did so after endorsing the report by the Minister of Police and an ad hoc committee report, which had both done the same. So the president simply did not comply with the remedial action ordered by the public protector. His position was that the public protector's remedial action was merely a recommendation and not binding. However, as the date of the Constitutional Court hearing approached, 8 days before the case was heard, Zuma circulated a draft order to the various parties which set out that he was of course bound by the public protector's report. Can you tell us a bit about the president's strategy? He had held a particular line for so long up until, court time, and then things changed. What was your reaction to all of this?
Well, I was not surprised that the president changed his mind, because there were discussions between his office and my office at all given times. It's just that sometimes he listened to people outside his office than he listened to people in his office. In fact, had he listened to his office, the matter would have been settled without ever going to court. I was not fully surprised that on Monday he came up with a different draft, because he requested to meet me on that Friday, and I met him, and he told me that he had decided to accept my decision, and he blamed his lawyers for misleading him about my powers.
The self-same president who had said in Parliament that they merely had the status of a recommendation, over a period of days before the court, made increasing concessions about their standing, until on the day capitulated and conceded that they were in fact binding. It's hard to tell how bad it might have been if he hadn't made the concession. But what I find hard to understand, well, let me say this, that if the president had in Parliament said these recommendations merely, these orders are mere recommendations and not binding, if he had defended that position before the Constitutional Court, one might have accepted that it was a good faith position held all along, albeit that it might be wrong. But having made the statement in the first place, to then concede before the hearing started that it was not correct, suggests that he never believed in what he said in the first place. But that is for him to explain. I can't see the advantage of making the capitulation, but one never knows. It does create a very bad impression to hold out for, what was it, a year or two, and then to arrive in court and concede that your position had been wrong all along.
The strategy adopted by the president on the papers, I thought, was a clever strategy. He first of all contested whether this was a case appropriate for direct access. And secondly, he said, look, you don't have to pronounce upon the merits of this at all, because the president has undertaken to implement the remedial action. So in a sense, all the squabbling about whether the public protector's powers are merely recommendatory or whether they have binding force is all academic, because the president's going to implement anyhow, so what's all the fuss about? I thought that that was an approach which had a future. First of all, as I've explained, because the Constitutional Court is very parsimonious in dealing with cases of direct access. And secondly, because the EFF was seeking an order directing the president to pay back the money. And I think that there might well have been some judges on the Constitutional Court who felt uneasy about imposing an order of that sort, given the background of these accusations of judicial overreach and breach of the separation of powers. Anyhow, a week before the hearing, literally a week before the hearing, we received a letter on the record addressed to all the parties. It was done via the state attorney, but it was copied on the court, which was effectively proposing a settlement. It said two things of significance. It first of all said that the president regards this matter as urgent and wants it disposed of, but he is prepared to accept the following order. And they set out an order which followed closely, but not identically, the remedial action which the public protector had imposed. So I think from a strategic point of view, those advising the president probably saw this as a good way of actually settling the matter and of avoiding a hearing in court at all. I think that they had underestimated both the EFF, who were the applicants in the court, and the public protector, whose report was at issue, because the public protector, my client, was not going to settle for anything other than the actual implementation of the actual remedial action which she had imposed, and she was not prepared to allow for a tinkering with that remedial action. So the matter came to court, and counsel for the president had conceded that the matter was indeed urgent and the president wanted it resolved. So the fights about direct access were effectively out the window when all the parties in the court were agreed that they wanted this finally resolved. And such squeamishness as some members of the court might have had about imposing an order on the president to pay back the money were also out the window, because the president had actually tendered to pay back the money. But the court was determined to hear the merits of the case, and it resulted in that somewhat ringing judgment by Chief Justice Mogoeng, which I think had a profound impact upon the public discourse around the Zuma presidency. And so I do think it was one of those cases which entailed a rather dramatic intervention by the courts, but could have been different, had different strategic decisions been taken. I, of course, speculate in that regard, and I certainly do not for one moment complain about the outcome, because it was a very, very powerful vindication of the public protector.
Another topic of interest is, of course, the amount of money Zuma was ultimately required to pay back.
One thing that I also just wanted to pick up in the Nkandla judgment was a bit of a discrepancy between your recommendations, well, your remedial action, and the order of the court. So you had asked for the president to pay back the money spent on a list of things: the amphitheatre, the chicken coop, the swimming pool, and I think 2 more things. And you said the list included these things. What's interesting about the judgment is the judgment limits the payment to these things, whereas your scope was broader. What was your reaction to that?
I noticed that, and I was even approached by Advocate Paul Hoffman with the view that I should write to the Constitutional Court and ask the Constitutional Court to change its judgment. My view was, in any event, it was impossible to ask the president to pay back all the money. And my decision was trying to make sure that the principle that says you can't use public money for your own self-aggrandizement needed to be honored. So the idea was to get as much money as possible, taking into account his circumstances. And yes, the Crown Court did close the list, and I think it was accidental, but I didn't feel that that was the kind of battle that we needed to pick. I thought the big one had been won.
The public protector had ordered that Treasury and SAPS determine all the non-security features of the improvements at Nkandla. And she said, including all they must determine, identify the non-security features, including, and then she mentioned 5 of them. But when it came to the Constitutional Court, and they gave effect to that judgment, they said Treasury must cost the non-security features, namely, and gave the 5. So that the president was ultimately required to pay only for the 5 examples Thuli Madonsela had mentioned. And I believe, the issue was debated before the court. The president argued that her report limited his liability to the 5 items, but the language was clearly the other way. Have a look at her recommendations. It says, blah, 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 including, and then the 5. And the Constitutional Court just didn't consider the issue in its judgment, but when it made its order, it says, pay for items, namely, and the 5. Now, I think he actually escaped significant liability there, because if all the non-security features had been included in the basket for which he was required to pay, it would have been significantly higher. It turned out to be 10 million out of 250 million, which was...
Yes, I mean, ultimately it was only 7.8 million rand that the president had to pay back.
I think it was a bit of an anticlimax that, 7.5 out of 250 million was all that it was seemingly about. But frankly, at that time, the big fight had been fought and the victory had been won, and nobody, I think, was terribly interested in exactly how much the defeat cost him. I am sorry that it wasn't 150 million rather than 7.5 million. But frankly, the war had been won by then.
Where the president ended up getting the money from is a further point of interest. He managed to take out a loan from VBS Mutual Bank. This bank, it later turned out, was at the heart of corruption, fraud and looting to the tune of roughly 1.9 billion rand at the time. But things get even curiouser. Millions of rands went to Brian Shivambu, who is the younger brother of the economic freedom fighter senior politician Floyd Shivambu. And, as we know, the EFF were the applicants in the Nkandla case. Various ANC politicians were also implicated in the scandal. The most devastating impact of all this was felt by poor rural communities whose savings were completely wiped out. The little these people had managed to put away, some over their entire lifetime despite extreme hardship, was simply stolen.
It always looked suspicious that the bank provided that loan, because we'd done the investigation on Nkandla. Nkandla at that stage was trust land, and banks were not giving loans for trust land, because trust land, the title is insecure. You have user rights rather than ownership rights. So it was always a little bit shaky. But now that we know that VBS dispensed a lot of favors to politicians to make them look the other way, it is up to the oversight institutions to hold everyone accountable. I hope for his own sake that President Zuma did not know what was happening. I hope for his own sake that there was a proper application for a loan and a proper application form. There was a proper valuation of his property, and there was a proper valuation of his ability to pay back. There were proper terms of payment, and those terms of payment were met. If you were to be willfully involved in breaking the law, then he would face the same consequences as another person who was involved in breaking the law. But it's heartbreaking, really, the story of VBS.
What were the EFF's motives in bringing this case to court?
I have no doubt that my client's motives were political and not an anxious defense of the rule of law in the first place. So, yes, but that is legitimately so. Not only political parties, there are lots of other interest groups come to court to advance their particular interests, but employ the law to do so, and that's a perfectly legitimate enterprise. The courts, of course, have to guard against the risk of becoming mere political instruments, but they have so far managed that very well, so there's no real risk of it.
Does the fact that a case is political affect counsel's argument before the court in some way?
At the margins, yes, not in substance. I don't argue bullshit. So I make an argument or I don't. And I wouldn't make a different argument or make an argument simply because the client on the day would like me to do so. But I may give my address a particular slant or a particular color if I knew that that would suit my client. Let me give you an example in this case. The papers which I had inherited and on which I argued the case made various points about the illegality of the president's conduct in his failure to implement the public protector's orders, and how that contravened the Constitution. One point that wasn't made was that by doing so he had breached his oath of office. But I submitted to the court, as I think I was legitimately entitled to do, that not only had he breached the Constitution in these various ways, but those breaches also constituted a breach of his oath of office. And I did so because I knew that that would have not only legally but also politically a particular resonance. And the funny thing is, there was then a debate as to whether he'd breached his oath of office, and there was suggestion from the court that accusation can only be made if it's deliberately done. And I conceded that the issue wasn't canvassed in the evidence at all. And for that reason, the court said nothing about that proposition. The judgment is silent on it. But the funny thing is that since then, everybody in the public domain have always said that the court held that the president had breached his oath of office. So it was an idea that found resonance and that stuck, despite the fact that the court ultimately made no finding about it.
Having worked with Thuli Madonsela, I don't think one should underestimate the extent to which she was personally victimized and threatened, yet stood firm in the face of overwhelming intimidation.
When you wrote your report, you wrote it in a particular era, and it was one in which I think very few people would have been brave enough to do what you did, which was tackle the most powerful person in the country and one of the most powerful institutions. Were you nervous at all? I mean, how was it for you to go out there and do what you did? And did you receive threats? How did the public protector survive StateCapture, the height of StateCapture?
Right. I wasn't nervous, I was sad. One of the things I have continuously mentioned was that I never took joy in the downfall of the wrongdoers. I wished we could have made a different decision. I wished they had behaved differently. And whenever I issued these reports where I had made findings of unethical conduct, I used to do so with a heavy heart. And I did so with a heavy heart here. But regarding intimidation, there was a lot of intimidation of myself, staff members in the investigation of the Nkandla matter, StateCapture matter, and other smaller corruption cases. There was a growing climate of intimidation, climate of insult, and then climate of framing people. Is it framing when they came up with that story? The State Security Agency took a very unhealthy interest in my office, and they came up with these ridiculous stories of spy stories. But I always say thank God that they were an intelligence agency with everything going except intelligence. Seriously. And thank God for that.
How exactly did people go about trying to intimidate the public protector?
With Nkandla, it just started with simple thing of saying you're not a security person, and therefore you shouldn't do this investigation. Then it got to the point of these spy stories. You are a CIA, Mossad, MI6, which is UK, and stories about having money in the Cayman Islands and things. And it got to threats, real threats, cell phone threats, letters written, people coming to their office and camping in our offices, claiming that we are prioritizing cases against black people, and as you can see, I'm black. We're prioritizing black people, and we don't deal with cases of historical injustices. And as you know, the public protector could only deal with cases post-1995 when it was established, and it could only deal with previous cases when there was a hook through which it could enter. The other thing was the State Security Agency just kept wanting to get involved. They wanted to vet, they wanted to deal with our intelligence system, our case management system. We said no. They asked me towards the end of my office for an opportunity to be vetted, because by 1994, I was 4 years into, by 2014, I'm 4 years into office, and it's in the middle of Nkandla. They request an opportunity to vet me. And I knew that this has nothing to do with vetting. It is just they want an opportunity to play shenanigans. And I didn't. And they wrote to me several times. They sent some guy that I knew at the State Security Agency to come and convince me that this would be good to me. And I had absolutely no idea how on earth would this be good for me. But having said that, I do think that we do need to find out what were the consequences of the state security agencies meddling in my office? And what is the legacy of that meddling? Because this is a crucial institution. It's not about it investigating the president. It's about its competence and its independence in investigating all cases, from a simple Gogo Dlamini case involving unpaid pension money to these big issues around tenders issued corruptly or even state capture.
Did you also receive death threats amongst?
Yes, I did receive death threats.
Numerous.
And my children also, yes. My children were also threatened. I even stopped walking because one of the SMSs that was sent, the person seemed to know that I walk in the morning, and the SMS was saying that they know that I walk in the morning with my son. It wasn't my son, it was my nephew. But they said they were going to kill my nephew and me. And we also had cars following us that my protectors picked up the details and sent them to SAPS to ask, what are these cars? But we never got a response, just to tell us in whose name are these cars registered that keep following us and parking in front of my house.
And did you have to up security during those times?
I really never didn't. I asked SAPS to up security, and the threat assessment was never completed.
At some point, the newly founded extreme left-wing political party, Black First Land First, invaded Thuli Madonsela's offices.
During the StateCapture investigation, they were practically living there. And if you were an ordinary good human being passing my office, you would have thought I'm a horrible person, because here are hungry, young, poor people sitting in my office and who claim that I have no interest in investigating their matter, whereas they had no interest in any investigation. What they had an interest in was to stop the StateCapture investigation. Witama and his people in the Land First, Black First, ended up emerging in a report in London, an official report, investigation report, as being funded by Paul Pottinger. But on that report, it's also clear that they were not funded by them. They were funded by a Zuma Gupta alliance. And it's not really foreign organizations that tried to destroy our institutions and that tried to sabotage an investigation. Based on the information that was found in London in a formal investigation by the PR Institute, it was Mr. Tutuzane Zuma and the Guptas that procured Paul Pottinger to implement what is referred to as a dead cat strategy, where if people are busy discussing something extremely important and it's an awkward moment for you, you just throw a dead cat on the table and then everyone forgets what was being discussed, because suddenly everyone is focusing on the dead cat, and they did just that. But they were masters of throwing dead cats. If you look at the history of my uncomfortable reports from Nkandla throughout, every time whenever I was about to release an report, they would throw something in the media on that day that tries to throw off the public narrative into something else. And they were helped then by the New Age and ANN7. It's easy to gaslight people who already are on the edge because of unemployment and inequality. I mean, our Gini coefficient is at 0.63. Inequality, poverty is at 55.5% generally among all groups. But if you look at those classified as African, at 64.4%, it becomes very easy to gaslight them on any issue. And the other thing we have to bear in mind is that the impact of that Paul Pottinger strategy was to put people on the edge, or to exacerbate existing polarization, and therefore we haven't healed from that.
What was the impact of the case? Did it play any role in bringing down Zuma, the president who has gone down in history for capturing the South African state in order to benefit himself and his cronies?
Perhaps the Nkandla decision became the beginning of his downfall, but not so much because of what he did wrong in allowing and encouraging the over-expenditure at his home on luxuries. I think it is his behavior in trying to avoid accountability that became his downfall.
That case was probably a tipping point, in that up to that point the rule of law was being eroded and undermined left, right and centre. But the case and that judgment of the Chief Justice, I think, was a tipping point and started to make a difference.
I think it was a case which had a dramatic resonance with ordinary people. And it was because there was really very little that was complicated about the facts. This was not I'm not saying it didn't involve technicalities and interpretive issues around the Constitution, but the underlying facts were very stark. Here was a person who had been given the task of doing an investigation, and here was a president who had enriched himself personally at the expense of the public. And so it was a very simple message which the EFF very skillfully brought across, and I do want to pay particular tribute to the way Wim Trengove presented the argument. It was that stark message which was so acutely portrayed during the hearing and which came out in the judgment, and ordinary people could understand that very, very simply. It was a moral issue for want of anything else, and one which was uncluttered by technicalities.
When I compiled this episode, I realized that in none of my interviews did my guests and I give serious consideration to the legal basis for the nature of the public protector's powers. We focus on the facts of the case rather than the law. I think this is because, as Gilbert puts it, those facts were so very stark. So we talked about these explosive facts, and the complex legal issues took a back seat. Might this perhaps have happened in the Constitutional Court as well? There is a well-known legal maxim, hard cases make bad law. In other words, an extreme case is not a good basis on which to develop law that may need to cover less extreme cases in the future. Did the Nkandla case cry out for a strong decision in light of the disturbing facts? The Chief Justice cast the case in biblical language. For a unanimous court, he wrote about the public protector as David fighting Goliath, namely corrupt individuals at the pinnacle of state institutions. Might the need for vindication of the former and accountability of the latter have precipitated a glossing over of, rather than a thorough engagement with, important legal issues? The court had to grapple with the legal status of the public protector's remedial action. Was such action merely advisory or obligatory? Or is there a field of grey in between, which was not explored to the extent it may have been had the court had different facts before it? Let's change the facts. If the public protector, for example, were to require that Parliament change the constitutional protections that govern the mandate of the Reserve Bank, would it still be self-evident that the public protector, now turned Goliath, should have her decision treated as obligatory? Would it not then have been much more necessary to articulate clearly what the constitutional basis of such a holding would be? This is precisely what has happened. The new incumbent of the office has taken to making decisions which demonstrate a blatant abuse of powers and which have required one court review after another. There are constitutional lessons to be learned from this. The determination of the powers enjoyed by a constitutional office should not respond simply to the facts of a particular case, but rather to the scheme of the Constitution as a whole. When making such a determination, it is paramount to consider how those powers might be used for good and, importantly, how they might be abused for malign purposes. Thank you for listening. I'm Cecelia Koch, and this was an episode of Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom.